morning. We're going to go back on the record to begin the hearing portion. Michelle, can you hear us all right? You're smiling. Great. Thumbs up. Want to check to make sure all the board members are here. I see that Mr. Moon is here. We have Ms. Davis in person. Steve Church, Borden, Levon, Garrison, and Mike Brown. I miss
I'm here. Can you hear me?
Yes, we can hear you now.
Okay.
Is that a trademark thing? We have to be careful. It looks like everybody is in attendance on the board, and we will go ahead and get started with the hearing portion. The first docketed item this morning is item number 1. It's per acre bonding costs for small mines and exploration. And the division will give us a presentation on this matter. And not sure exactly who gets to do it this time. Is there somebody representing the division on this?
Yes, Mr. Chair, we have Wayne Western, Peter Brinton, and Kim Coburn. They are in a conference room there in the division office. They should be able to bring their PowerPoint up and then go ahead with the presentation.
Okay, thank you. Please proceed.
Mr. Chairman, members of the board, can you hear me and can you see the presentation?
Yes, Wayne, we can hear you and we see the slideshows.
Okay, my name is Wayne Western. My colleagues Kim Coburn and Peter Brinton have assisted me in preparing the per acre costs for small mines and explorations. And so I want to make sure that they get full credit for all their hard work. And I will begin the presentation by saying that every year we are required to do a presentation before the board to give our per acre costs presentation to the board so that they can vote on it. For small mines and exploration projects, a lot of times you're dealing with small operators that don't necessarily have the expertise, or in some cases it's just not cost effective for them to do a full reclamation cost estimate. And so many of them have requested that they would just prefer to use the per acre cost, which is set forth in the division rules. If someone does not like the per acre costs, or if they feel that there are circumstances that don't necessarily apply to them, they have different options. One is that they can have the division prepare the cost for them, and this sometimes happens specifically for some very small minor operations, or they can come up with their own estimate and have it verified by the board. This is outlined in R645-3-111.3. Just wanted to point out that these are bonds, they're not fees. The operator will get all their money back when they complete operations and reclamation. The board establishes the per acre cost for the reclamation bond, and the division gives a presentation to the board, and the public has an opportunity for comment. This year that might be a little difficult because of some of the COVID restrictions, but in the past there's been very limited public comment on this. Some changes for 2021 is that SB 131 allow for permitting of small mines up to 20 acres. This is up from 10. And so for our model mines, traditionally we've gone from 1 to 5, 6 to 10, and now we're having model mines for 11 to 15 acres and another one for 16 to 20 acres. These model mines are based on direct and indirect costs. As seen on the screen, the direct costs involved earthwork, revegetation, horticulture, and surface facility removal if necessary, and that's usually a line item. And then we also have our indirect costs, which is mob, demob, which in some cases for small operations can be very significant. We have a contingency fund in there because no matter what, usually things cost more and take longer than what you anticipate. And we have some costs for administration, and so they are broken down here. Contingencies of 10%. Contingency is not a slush fund, but it's just that we do know that occasionally we will get overruns, engineering redesign, main office expense. These are usually used to cover things like working out detailed costs and bid packages for the operators to work on. So the total is 21.8%, and mob demob is handled separately. Traditionally, we have used the equipment watches, Blue Book, and RS means. These are pretty much well established within the industry. And for our model mines, we use the Tech Directive 007, which the coal program has been using for the past 25 years. And a few years ago, OSM reviewed our Tech Directive, and with a few tweaks, found that it certainly is adequate for purposes of reclamation. Escalation is required. We use RS means historical construction cost index. We go back 5 years and project that into the future. This year we have 2.69% escalation per year, and the operators for small mines have the opportunity to either choose a 3 or a 5 year escalation. Now turn the time over to Peter.
All right, I'll try to speak loud. So based on the information that Wayne shared, the model mines were developed, as he mentioned, for 5, 10, 15, and 20 acres. And the division continues to evaluate large mines and large mine bonds if those mines are under 50 acres in size for comparison. And so these model mines are basically assuming similar equipment and productivity rates as for smaller large mines, and the same thing for the unit costs. They're also the same. The 5 to 10 acre model mines have some assumptions that are as shown here: minimal surface facilities, so that no removal or demo is required. Also, no leach pads, and the assumption is that it's an excavator or a dozer. 15 to 20 acre model mines have similar assumptions, with the exception that, as you can see here, the truck and the loader is added onto it. For 15 acres, it's a truck added on, and then the loader is added on for the 20 acre. So some of the equipment, what went into the equipment selection were some of the factors you can see here. Haul distances. The assumption is that, well, it's true that for 10 acre mines, you're going to have a smaller haul distance. And so that went into the selection of the equipment used for the model mines. And as you can see here, the dozers used, the characterization of the dozer uses for pushing materials short distances. The excavator's assumption is that it'll be digging materials, truck will be hauling soil and trash, and the loader will be for loading soil. Then in addition to these, we also have costs in these model mines for pickup trucks for support, as well as the equipment operators, and then a laborer as well. The 5-acre model mine, you can see the assumptions for the hours used in determining these per acre amounts. And then once we have in this case, 50 hours of total excavator use, and as well as other costs for the truck and the operators and the laborer, then we come up with the total cost for these 5 acres, divide it across the 5 acres, and that's how we develop a per acre amount from that total cost. The same thing is done for 10-acre operation, or the 10-acre model mine. In this case, as we mentioned, it's a dozer. Same thing, we'll divide by 10 acres and then add in the other smaller costs for, as we mentioned on the previous slide, and then come up with the per acre amount. 15-acre, the hours increase with the addition of a truck, and we come up with a per acre amount in the same way. And then for the model mine, 20-acre model mine, you can see that the loader has been added. The same process is used for developing a per acre amount.
So one of the other things that you'll see in your packets today is a memo that summarizes all of our bond costs. In there, you'll see a MOB-DEMOB calculation. And this is just simply how close is it to the nearest place that you can rent equipment. So we use wheeler dealerships because the state has a contract with them, and we periodically go through and evaluate where all the wheelers are located, if there's any new ones, because that will help us be able to get to the mine safe more quickly. If they are farther away from city centers, then we have to assume that we have to bring a pilot car. There's going to be a little bit more cost of getting the equipment out to where we need it. We also, I just want to reiterate, but if a site has some type of facility, such as like a scale house or any buildings, those are handled separately as long items. So our costs that are associated with the small mine calcs are just based on a per acre basis, but we also have several other unique costs, such as we bond portals at $2,000 and shafts at $3,000. This is based off of our AMR calculations. These are just line item costs that have been escalated. They also include like a 1 acre of disturbance typically for the different specific mines. We do site specific for very unusual larger shafts. And we also do a set cost for drilling as well, based off of our oil and gas program. Other things that we add into there is if they have reclamation where we're waiting on vegetation to grow, we put $1,000 in there if we're planning to do earthwork at a later time. But if they're doing, if they need to reseed an area and they already have other earthwork, then that mob is already taken care of, which is why it goes down to $500. Our exploration costs and costs went down from last year. We had less fuel costs, so it went down from 2020. So now it's $7,600. We evaluate exploration bonds on an annual basis, while for small mines, we evaluate on a 3-year or 5-year basis. So our unit cost for our up to 5 acres starts off at $8,000 for 3 years. So that means that it's good until 2024, or $8,400, which means that the bond would be good until 2026 for 1 acre small mine that's close to a city center. Every additional acre is $5,200, 55 acre up to 5 acres, where the total for a 5 acre small mine for 5 years until 2026 is $30,400. For our 10 acre mine, the cost increases as Peter was describing with additional equipment, where the cost on the per acre basis went up to $6,600 for 3 year, or $7,000 for a 5 year, up to a total of $69,200 for a 5 year escalation mine. This year is new, where we're introducing our 11 acres and up calculations based off of SD 131 as Wayne described, where for 15 acres, our costs have gone up to $111,100 for a 3 year and $117,300 for a 5 year. Our top cost based off of our models is for 20-acre mines, which also have increased based on the additional equipment that's on site, up to $175,700 for a 5-year escalation or up until 2026 as our maximum right now. But these general per acre bond amounts, the methodology behind it really remains unchanged, where our biggest thing that we added was we added in additional models to account for the 11 to 20 acre variances that was required by legislative. But overall, the cost decreased on the smaller per acre bond amounts from 2020. And we recommend that the board approve the per acre bond costs submitted in that memo and in this presentation until our next presentation in 2022. So does anyone have any questions?
Board members, questions? Rich?
Yeah, I have 2 questions. I guess a comment and a question. I just quickly worked up for a 20-acre disturbance. You could probably fit in a pit with a 200 or 300 foot tall high wall in there. So it's getting to be a pretty big disturbance. Do we know, for these larger mines, do we have some examples in the historical record that the division has reclaimed in that size range that these costs can be compared against to validate or to calibrate them and make sure that we're numbers?
There was at least one operation that had that was over 20 acres in size. It was different in the sense that it didn't really have a pit area, and so as you can imagine, on mines like this, there's wide variation in types of operations and level of disturbance and reclamation required. So I'm not sure if there's one recently.
We have in the past, when it comes to reclamation, generally have enough money unless the operator has gone outside of their permit boundaries. So the going up to the 20 acres is somewhat of a new venture for us. And what we're looking at is comparable mines, and based upon what we see in the bond calculations for mines that are in that range, up to 50 acres, the per acre cost is very similar to what we're seeing in some of the larger mines. So yes, you could theoretically get into a very deep pit with a lot of high walls. That is something that we have looked at, but for the typical mine, 10 to 20 acres, we're fairly confident that these numbers are sufficient to ensure bond reclamation.
Okay, thank you.
Any additional questions?
Yeah, I believe Ms. Davis has a question.
It seems like whenever the board gets involved in a reclamation, the bond amount is not sufficient. I'm not quite sure why that is. Looking at your methodology, Hewitt comes to mind really quickly. Can you comment on that? Why is it that we end up looking at people and mines and wells and there isn't sufficient bond money to reclaim them?
Okay, as far as wells go, that is over with the oil and gas, and they have a separate procedure for determining bonds. Usually when we come into overruns, it's because the operator has mined outside of their permit boundaries, so they have more disturbance than what they were currently bonded for. So so what we are trying to do to combat that is to up our inspections, and we're now, one time we were only inspecting small mines, once a year, once every other year. Now we've set a goal of inspecting them twice a year, because they're generally the mines that we have more problems with bond forfeitures. Does that answer your question?
Yes, thank you.
And Wayne, though it's not preferable or we don't really want to do it, I assume that the division would be prepared to assess penalties against an operator that might cover the difference between the bond and the actual reclamation cost.
Yes, we can do that. We can seek more funds from the operator after we've gone through and reclaimed. Sometimes, that's not always possible if they're out of business, broke. But we are very aware that it's our job to do our best to ensure that the public is not going to be on the hook for reclamation, because it's the operators that go in there and have the ability to make profit, and it's not the public's responsibility to clean up after them.
Hey, one other question. If in the scenario that board member Borden suggested, would the division not have the opportunity to evaluate their plan and increase their bond as needed?
The division can, when they're falling under the small mine permit, all they have to do is submit basically 7 pages and 2 maps. So we don't have very detailed calculations of what the mine is going to look like. And it's something that, as an inspector could look at and reevaluate the mine, seeing if, you do have a deep pit with a lot of high walls on it. The division could later on reevaluate the bond and set it higher.
Okay, thank you. I see Ms. Souza has a comment she'd like to make. I believe you're muted still.
Sorry. I was, thank you. I was hoping to address just a couple different comments. So to Susan's comment about underbonding, my experience in this arena has been limited, obviously, to the last year. I think we brought a handful of forfeiture cases in the minerals arena. And I think of those cases, maybe one of them was underbonded. In the minerals context and in the coal context, because our rules allow for full cost bonding, it's something that we see a lot less in the minerals program. We see it commonly, as you know, in the oil and gas program, which hopefully will be something that's addressed in the upcoming bonding rulemaking. But in terms of the minerals program and the coal program, we see a lot, our cost estimates for reclamation are substantially closer to where we actually end up in terms of actual cost for reclamation. And then the second comment I was hoping to make was addressing a comment that from you, Chairman Hansen, about the division's ability to assess penalties that would cover the difference between actual reclamation costs and the bond amount that we have. And actually, unfortunately, the Utah Mined Land Reclamation Act mandates that any fees we recover from penalties, any fines we recover, have to go into our abandoned mine reclamation program fund. So we can't actually use any funds that we collect from penalties to cover those costs. But as Wayne was noting, the inspectors are out there, and so they are seeing when people go outside their permit boundaries. And so in those instances, we are immediately requiring additional bond be put up so that we can make sure that we have adequate bond coverage. And I yield back.
Thank you for that additional information. That appreciate that clarification. Mr. Borden.
Thank you, Chairman Hansen. I just wanted to follow up on something you had said and asked about the mine plan that is submitted for one of these small mines, less than 20 acres. would that submittal include whether or not there's a piece of significant fixed infrastructure in place that would require demolition? In which case, would you be able to modify the bond for that?
There is space when we ask for certain facilities. So yes, we could put in, we could identify that and put that in as line item for demolition. Typically for your smaller mines, your under 10, there's really not a lot of need for infrastructure, but as you're getting up into your 20 acres, then it's not uncommon to see things like fuel tanks, sheds, maybe an office, scale house, something like that. So when we're evaluating, yes, we will be looking into the demolition of the structures in your larger mines.
Okay, yes, I thought that might start coming into play when we're starting to move into these larger scales of disturbance. Thank you.
Mr. Brown.
Thank you, Mr. Chairman. One last question for me, if I may. In the event that a third party or another entity acquires a property, a mine, is there an opportunity for the division to reopen the bond at that point and make sure that the costs are where they need to be?
Yes, the answer is yes. I see that Ms. Sosa is nodding her head. And so, yes, on transfers, we do have an opportunity to reevaluate the bonds.
And how frequently is that evaluation completed?
We don't do a lot of transfers, but when we do, we will take a look at the bond, particularly because the new operator has to post the bond, and we'll review the situation on the ground. So I would say generally that's not a common thing, but it does happen.
Thank you. Mr. Chairman, if there aren't other questions, I'm prepared to make a motion.
I believe Levon has a question.
In the past 5 years or so, have you had any situations where you've had extraordinary costs that have exceeded the funds you have available?
I'll let Ms. Coburn answer that one.
Yes, but the key is we can send you Tech Directive 7. These are circumstances that are not accounted for in that methodology. So an example is that we had an oil spill on one of our sites. We assume that when we go into reclamation, the site is fully compliant, that there are no issues like that. But when you have an oil spill, that's not accounted for. We don't penalize every single mine out there for those type of circumstances.
Thank you.
Thank you, Ms. Garrison. Back to you, Mr. Brown. I think unless there are other questions from the board, Mr. Brown, you had a motion you would like to make?
Yes, Mr. Chairman, just one editorial comment ahead of the motion. I think when the board looks at bonding costs, our responsibilities are at least twofold. Number one, to ensure that the public doesn't wind up bearing the cost of an inadequately funded disturbance. But number two, to ensure that we don't prevent small miners from entering into the business and developing these resources and therefore giving large mining operations a competitive advantage. So I'm satisfied based on what I've heard here today to make a motion to approve the recommended per acre amounts that have been proposed to us by the division. Thank you.
Is there a second to that motion?
This is Rich Borden. I would second that.
Discussion on the motion? Seeing and hearing none. We will vote on the motion. Ms. Julianne, would you please call the roll call vote?
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. Levon J. Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon L. Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
Thank you, Julianne. I guess at this point, I'm not sure that that we have anything more to do with it other than thank and assume that the the bonding costs will be implemented. We'll move on to the next docketed item, or agenda item, docket number 2021-006, cause number 072-01, in the matter of the request for agency action of Urban Oil and Gas Group, LLC. It's our understanding that this matter was going to be heard before the hearing examiner, scheduled for the 17th of March of this year. It has been postponed to address some issues until April 14th. So that matter has been moved to April, and we'll move on to the next agenda item. Item number 3, docket number 2021-007, cause number 475-04, in the matter of the request for agency action of CH4 Finley Operating LLC for an order granting an exception location for the RP Tribal 25S-31W-H1UB well located in Uinta County. Do we have the representatives here? Do we have appearance of counsel in this matter?
Yes, Mr. Chairman. Fred McDonald of counsel with Lear & Lear on behalf of the petitioner.
Thank you, Mr. McDonald. Division?
Haley Souza on behalf of the division.
Okay. Mr. McDonald, would you like to proceed with your opening statements? And then I assume if you have witnesses, we would swear them in at the time, appropriate time.
Yes, Mr. Chairman. With me today are Ms. Deidre Stoley, who's the in-house counsel for CH4 Energy Finley, Utah, LLC, and Mr. Shay Atkins, who's the geology manager for Finley Resources, Inc. Both of those entities are members of the petitioner, and I would ask that they be sworn in at this time.
Michelle, could you swear in the witnesses, please?
Yes. Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Members of the board, the resumes of the witnesses were collectively submitted as Exhibit A in this matter. If asked, each would confirm the information reflected on the respective resumes is true or correct. Ms. Stoley will be a fact witness only. Mr. Atkins has been previously recognized as an expert in geology by the board on several occasions. Presuming the division has no objections, I would request that he again be recognized as an expert in geology for purposes of this cause.
Board members, any objection? Ms. Sousa, any objection by the division?
No objection, thank you.
Okay, they are accepted as expert witnesses in this matter.
Thank you, Mr. Chairman. I'd also like to confirm that the board members and the division have received the supplements to Exhibit G and to Exhibit Z that were filed on Monday.
Hold on just a minute, I can make sure. Yes, we have, thank you.
Thank you. And finally, I'd like to confirm that we're going to move for admission of our exhibits at the end of our presentation, Chief.
Yes.
Thank you. Members of the board, CH4 Finley Operating LLC today seeks approval of an exception location for the as-drilled RP Tribal 25S 31W H1UB well, which is a long lateral horizontal well drilled in the Uteland Butte member of the Lower Green River Formation. The board established sections 25 and 36 of Township 3 South, Range 1 West as a drilling unit for long lateral horizontal wells producing from the Lower Green River Wasatch formations in its order entered in cause number 139-134 as amended by the order entered in cause number 600-01. Under these orders, no productive interval may be located closer than 560 feet to the east and west drilling unit boundaries. As will be addressed in today's testimony, due to a survey error, the subject wellbore drifted during drilling closer than 560 feet to the eastern drilling unit boundary. However, the maximum deviation from the 560-foot setback is just 11 feet. Based on the average fracture half length and orientation, the deviations will not result in any adverse impact upon the production interest owners in the adjacent drilling unit to the east. The well has not been completed due to this deviation. To remedy the deviations and allow well completion and production, CH4 Finley requires an exception location approval. CH4 Finley has obtained the written consents of several owners in the adjacent drilling unit comprised of sections 30 and 31 of Township 3 South, Range 1 East, but not all parties have responded. As a consequence, CH4 Finley must seek an exception location approval directly from the board under Rule R649-3-3. True and correct copies of the 139-134 order and Rule R649-3-3 were collectively submitted as Exhibit B in this cause. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-5, subparagraph 3B, and Utah Administrative Code Rule R649-3-3. Notice was sent via certified mail, return receipt requested to all owners, as that term is defined by statute and regulation, and operators within the respective Section 25 and 36 and Section 30 and 31 drilling units. These mailings were sent to the parties at their last addresses of record, as disclosed by the relevant state and federal agency records, the realty records of Uena County, and the internal land records of CH4 Energy Finley Utah LLC and Finley Resources Inc. The record would also reflect that notice was duly published on March 3rd, 2021 in the Uena Basin Standard and Vernal Express, on March 5th, 2021 in the Deseret News, and on March 7th, 2021 in the Salt Lake Tribune. The division elected not to submit a staff memorandum in this cause, and no other objections or responses were received. With that, I'll commence my examination of Ms. Stoley. Ms. Stoley, please state your name and business address for the record.
My name is Deidre Stoley. My address is 5128 Apache Plume Road, Suite 300, Fort Worth, Texas, 76109.
And what is your position with the petitioner?
I'm in-house counsel with a background in professional land management, and I currently supervise land issues in regards to the subject lands.
For the record, would you please state the corporate and bonding status of the petitioner?
CH4 Finley Operating LLC is a Delaware limited liability company in good standing with its principal place of business in Fort Worth, Texas. We're duly authorized to conduct business in the state of Utah and are fully bonded with all relevant state of Utah and federal agencies.
All right, I'm now going to present our PowerPoint. Please let me know, is everybody seeing this?
We can see it here.
All right, thank you. Ms. Stoley, I'm going to direct your attention to what have been marked as Exhibits C through H in this matter. Do you recognize these exhibits?
I do.
Are they prepared by you or petitioner personnel with your supervision and review?
They were.
Turning your attention to Exhibit C, would you please explain to the board what this shows?
This is just a regional map showing the area at issue. It's located approximately 7 miles due south of Ballard City in Uinta County.
All right, and the red box represents the drilling unit we're talking about where the well is, correct?
Yes, it does.
Okay, now turning your attention to Exhibit D, would you please explain to the board what this shows?
This shows the subject unit in red, which is comprised of sections 25 and 36 and 3 south, 1 west, and the adjacent unit, 3 south, 1 east of sections 30 and 31. The red line is the approximate location of the subject well. The blue lines are existing horizontal wells in the adjacent unit, and the green circles are existing vertical wells in the unit. CH4 Finley operates all of these wells on behalf of CH4 Energy Finley, Utah LLC, and we've been the designated operator on behalf of the unit issued by various Finley Resources entities.
All right, turning your attention now to what has been marked as Exhibit E, please explain what this represents.
This is the plat showing the oil and gas ownership in section 25 and 36. So you can see tribal ownership is at 59.9%. Alati ownership at 11.37 and fee at 28.73. And CH4 Finley, CH4 Energy Finley, Utah is the majority working interest owner in this unit.
Now moving to Exhibit F, would you please explain to the board what this represents?
A similar plat for the adjacent unit in sections 30 and 31, tribal ownership being 27.84%, Alati at 5.9%, and the remaining 66.26 being fee ownership. CH4 Energy Finley, Utah is the majority owner in this unit as well.
All right, turning your attention now to Exhibit G as supplemented. There is not a PowerPoint for this. Can you please, these are true and correct copies of the requests sent out for an exception location approval, is that correct?
That's correct.
Were they prepared by you, and are the responses the official business records of the petitioner?
They were, and they are.
All right. And not everybody responded, is that correct?
That's correct.
Okay, now turning your attention to Exhibit H, would you please explain to the board what this represents?
So this represents the consent that had been obtained as of the time of filing. Since that time, we've actually received more responses, and the current consent is at 96%. The remaining 4% have not responded, and we have received no objections.
All right, and I'd like to point out to the board, because not all the owners in this adjacent drilling unit have formally consented in writing, Rule R 649-3-3 prohibits administrative approval by the division. Consequently, the petitioner had to file this request to obtain board approval of the exception location. Now, Ms. Stoley, I'm going to direct your attention to the certificate and the supplemental certificate of mailings. These are pleadings prepared by my office and are on file in this cause. Do you have those in front of you?
I do.
And do you recognize the names that are listed on those documents?
I do.
Who are they?
They're the owners of sections 25 and 36 and sections 30 and 31.
All right, and how were these names and addresses compiled?
From our internal land records, which were generated from a combination of searching BIA, board, and relevant county records.
All right, and again, pointing out to the board, Exhibit Z is supplemented, is true and correct copies of the return receipts received by my office for the mailing of the request, or of the Postal Service inquiries as to the status of mailing for which no return receipts were received. With that, that concludes my examination of Ms. Stoley.
Division, do you have questions of this witness?
Thank you, Chair Hansen. I have a few questions, and if the board will entertain, Mr. Dustin Doucette may have some as well. But I will get started. So 96%, you've received 96% consent. So I'm guessing that means that since the supplemental filing that was on Monday, that you guys have received additional consents. I think that supplemental filing had 4 consents.
That supplemental represents that increase from 92% to 96%. This 92% was the original from a month ago.
Okay. So can you, because we didn't see the previous consents that were signed, we only saw the version that you guys sent out. How many owners have not consented? So how many owners comprise the 4% that's remaining?
That is 4 owners.
4 owners. And are those the 4 owners that were unlocatable? That the green cards came back as undeliverable?
Oh, I'm sorry. I thought I misunderstood. Okay, the 4%, we've not received any response back. Formal response. There has been an indication from somebody that represents a few of the family members that they were not going to make a decision. We're going to trust the board's judgment, but they did not send an official response.
Okay, and so how many of all of the owners, how many have consented versus how many haven't consented?
So we consented as a working interest owner, 4 others consented, and the non-response represents 1, 2, 3, 4, 5. So 5 official of record owners. Record title for one of the owners we haven't heard from is a couple that deceased quite a few years ago. So we, in our attempt to locate them, have been trying to find heirs. So we included the heirs that we knew on this list, or we suspect. There's intestate issues, various probates to be done. We do not have, with absolute certainty at this point in time, know the true number of heirs, but we have hired brokers to do that. So I can't give you an exact number of who all has not responded, if that makes sense.
And did you receive consent from the tribe?
No, we did not. We did receive no response. But actually, that was a more formal notification, as officially the only unlease that they have would be over in 25 and 36, and every bit of 30 and 31 has been fully leased by us as lessee.
Can you just elaborate a little bit more on the efforts that you undertook to locate each of the individuals, particularly the 4 that you guys were not able to give notice to?
Well, first, as we started, our initial mailings go from the current address and name of record title ownership. We feel that that's the best starting point. Once we have some indication that that is the wrong address, such as returning undeliverable, hearing, from a family member that is wrong, we actually pay a subscription service that purports to be one of the best at giving current address and contact information. And so we run those names through this service to try and find updated information and try and match up addresses based on dates, times, and track them down, and then resend to those addresses.
Mr. Doucette, do you have any additional questions for this witness?
Yeah, maybe just a quick follow-up on Exhibit H. These ones waiting on consent, are these all on leases that are separate divided leases, or are they, is it like an undivided lease where you have portions of that lease and it just signed on and some are not?
That's correct. They're all a smaller undivided interest in those tracts. So we do have some consent in every single tract covering the unit.
Okay. Thank you. That's all I had.
And Chairman Hanson, that's all I have as well. Thank you.
Members, do you have questions for this witness? Ms. Davis?
From Tribal, the Tribal has quite a bit of interest in these plats sent.
Excuse me, cut out for a second. Could you repeat that question?
Do you have tribal consent in these plats?
No, we didn't request formal tribal consent.
They have quite a bit of interest in that. Why is that?
Because we're the current lessee of these, and as the working interest that represents the tribe under the lease rights, we gave consent to ourselves. They were notified of this, and we did not receive any response from them stating that they had any objection to this.
Thanks for that clarification.
We may come back and visit this issue in a few minutes, but for now, let's, Mr. McDonald, if you'd like to proceed.
Thank you, Mr. Chairman. Now I'll commence my examination, Mr. Atkins. Mr. Atkins, would you state your name and business address for the record?
My name is Shay Atkins, business address of 1308 Lake Street in Fort Worth, Texas, 76102.
And what is your current position?
My current position is Geology Manager for Finley Resources, Inc., as well as CH4 Finley, Utah, with supervision over all assets in the state of Utah.
Can you make any representation on behalf of Finley Production Company or any of the Finley related entities with respect to this request?
Yes, as a representative of Finley Production Company with working interest in sections 25 and 36, we express our support for this RAA.
All right, turning now to your attention to exhibits I through N in this matter. Do you recognize these exhibits?
Yes, I do.
All right, were they prepared by you or petitioner personnel with your review and input?
Yes, they were.
All right, turning your attention now to exhibit I, please explain to the board what this represents.
Exhibit I represents the original well plat prior to drilling of the RP Tribal 25S 31W H1UB. And this illustrates a bore path that parallels the eastern section boundary of these two sections at a distance of 610 feet from that eastern section line, which is 50 feet west of the 560-foot setback per board order 139-134. And the intent of this location of 50 feet away from the hardline setback was to maximize recovery in the DSU and prevent waste while also allowing a 50-foot buffer for any unforeseen deviations while drilling.
Now turning your attention to exhibit J, please explain to the board what this represents.
Exhibit J represents an as-drilled well plat. And so while drilling the well at approximately 17,700 feet measured depth, information was presented to CH4 Finley suggesting that due to the drill bit walking to the eastern direction, that the bit had actually crossed the 560-foot setback buffer. At which point, as soon as this information was presented to CH4 Finley, we stopped drilling and called TD and terminated drilling on January 23rd of this year.
And the well hasn't been completed though, has it? You stopped drilling and it hasn't been completed?
That's correct. The well has not been completed. And so the as-drilled well plat revealed that the bit had in fact crossed the hard line at this point for a distance of 105 feet or one stand of drill pipe, and that the bit was projected to be 8.42 feet past the hard line.
All right, turning your attention now to Exhibit K, please explain to the board what this represents.
Exhibit K represents an as-drilled well plat as we further reviewed the information that was presented to us and became aware that while the original well plat presented a bore path that paralleled the section line, that it actually does not parallel the section line, and in fact moves along. It does not parallel, and the section line is in fact diagonal. And so due to this shift of approximately 20 feet, caused the deviation that we're now discussing.
So bottom line was the original survey plat was incorrect in the survey of the east section line. Is that correct?
That's correct.
Okay. Turning your attention now to Exhibit L. This is a 4-page exhibit starting with page 1. Please explain to the board what it represents.
So based on the information from the previous plat, we hired a second survey company to redo the survey and prepare an as-drilled plat to confirm the information. And this as-drilled plat revealed that the wellbore had in fact crossed the 560-foot setback at 3 locations along the length of the lateral, with a maximum deviation of 11.83 feet and a total lateral length of 1,552 feet. But majority of this distance is only 1 to 3 feet inside of this setback boundary.
Turning you now to Exhibit L2, please explain to the board what this represents.
And so we look at location number 1, where the wellbore crossed the setback. It's 1,148 feet in length with a maximum deviation of 11.83 feet at one point, with majority of this distance within 1 to 3 feet of the setback.
Now turning to Exhibit L3, please explain to the board what this represents.
Location number 2, where the wellbore crossed, is a total of 404 feet with a maximum distance of 3.32 feet inside the setback. And
finally, page 4, please explain to the board what this represents.
And finally, location number 3 is what we previously looked at, where CH4 Friendly called TD as soon as we became aware of this instance. And so resulting factor is 105 feet of the wellbore is across the line with a maximum of 8.42 feet. Once receiving this information and confirming these 3 locations, we notified the division on February 4th. And as stated previously, have not completed the well, but currently have a completions crew working with plans to complete it in mid-April.
All right, and what was the division's response when you notified them of the deviations?
The division's response was to seek an exception location.
All right, and so the timing with completion is you have contractual obligations to complete sometime in mid-April. Is that correct?
That's correct.
All right. Turning your attention now to Exhibit M. This is a 2-page exhibit starting with page 1. Please explain to the board what it represents.
Exhibit M represents some data that has previously been presented to the board. This is some microseismic data that CH4 Finley has on direct offset horizontal wells adjacent to the application lands. This data is from 3 horizontal wells and represents the average fracture half length of 252 feet and average orientation of these fractures at north 85 degrees west.
Turning to the second page then, please explain to the board what this represents.
Exhibit M2 is supporting data for the previous slide. And so if you look in the top left corner is a locator map for the star represents the microseismic for the data below. And so starting on the right, There's kind of a lot of dots going on here. So these are individual microseismic events that went into that are the supporting data presented on the last slide. This is a map view of microseismic events per stage. The center two diagrams are rosette plots. It's a combined plot of the orientation of all of these data points along the wellbore. And then on the far left is a three-dimensional view of the data points collected and how all of these measurements are taken to come to these conclusions.
Now turning to Exhibit N, which is another 2-page exhibit. Starting with the first page, please explain to the board what this represents.
And so Exhibit N1 takes the data presented on the previous slides and puts it into an illustrative scenario looking at the buffer from the section line that we're discussing. So the diagram on the left, you see the red dashed line being the 560-foot setback. On the left, you see the black hard line being a theoretical wellbore path. And then at the toe is the north 85 degrees west fracture orientation of an ellipse with a 252-foot fracture half length. And so taking this information and applying it to a wellbore that is 12 feet inside of the 560-foot setback results in a remaining 297 feet of buffer space to protect offset mineral owners. And so based on this data, we believe that completion of this well will not infringe on any correlative rights of the adjacent lands.
Okay, turning to the second page, please explain to the board what this represents.
And so Exhibit N2 is a very similar illustration, but an exaggerated cautionary scenario of saying, okay, we're 100% wrong, and the fracture half length is actually 504 feet, so it's twice as long as previously presented, using the same fracture orientation and the same scenario previously presented with a wellbore that's 12 feet across the 560-foot setback, still results in 44 feet of space remaining to protect the offset mineral owners. And so therefore,
go ahead.
Yeah, so even doubling the fracture half length, we still believe that correlative rights will be protected in this scenario.
Okay, let's take it to the ultimate extreme, that even if this is wrong and for some reason there's an elliptical that would go over into the adjacent drilling unit, what would CH4 do to assist the production interest owners in section 30 and 31 to offset any advantage of that scenario?
Right. Assuming that scenario is correct, then CH4 Finley is prepared to provide a written consent to allow a similar exception location in an offset well.
All right. Is it your expert opinion then that based on the known deviations in the microseismic data and analysis, no adverse impact will result to the production interest owners in the section 30 and 31 drilling unit if the subject well is drilled and completed and produces as is?
That's correct. Yes.
Thank you. Mr. Chairman, that concludes my examination. Mr. Atkins.
Thank you, Mr. McDonald and Mr. Atkins. Division, questions for this witness?
Thank you, Chair Hansen. I don't have any questions for Mr. Atkins, but I would request if Mr. Doucette has some that he be allowed to ask those questions.
Please proceed.
Yeah, Dustin Doucette for the division. Maybe just one question. I know some of those offset wells that you used for this microseismic data, how long have they probably haven't been drilled and producing very long. What length of time have they been producing?
I do know the direct offset, the one used as the closest comparison, was drilled and completed in 2017, I believe.
And so, based off of that, I mean, what is your expectation as far as drainage outside of those microseismic events? Do you have any data from existing wells, or what is your expectation for the drainage beyond the tips of those fractures, basically.
Right. So given this target, we're all of these wells presented are drilled in. It's my opinion that there's storage space, there's porosity that holds hydrocarbons, but there's not perm. There's low permeability, and so the only rock that you're effectively draining is what is connected with the completion, with the fracture stimulation. So that's in our opinion that the only rock that you're effectively draining is that you touch with your completion.
Okay, thank you. That's all the questions I have.
Board members, do you have questions of this witness? Mr. Borden.
Yes, you had stated that the maximum deviation into the buffer zone was 12 feet, and along most of the length, it was only 1 to 3 feet. Do you have an estimate of the average deviation across that line?
Yes, sir. That's sort of what I was getting at. It's roughly 3 feet. It's just shy of 3 feet is the average. I could have stated it that way.
Okay. So that means we're talking about something that is 0.5% of the buffer zone has been consumed, if you will.
Yes, sir. That's correct.
Thank you.
Mr. Moon.
Yeah, as a mineral owner, I just wanted to compliment CH4 Finley for being forthright in this. It's as Rich pointed out, it's a very small deviation, 3 to 11 feet over just a small portion of the drill bore, but to admit to, the small mistake and at quite an expense here for all of this, for this board hearing, et cetera. I just appreciate CH4 Finley and just wanted to mention that. I do feel bad though that I just ask one question. Why did you stop drilling? Why not deviate back within the buffer zone or out of the buffer zone and finish the well? What went into that decision to just stop drilling? Because there's over 1,000 feet of producing area there that I don't know how you're going to access in the future. So just wanted your thoughts on that.
Right. So at the time of call and TD, the drill bit was building hard towards the eastern direction. We did some calculations to see how much lateral length it would take to get back across the buffer zone, and in order to arrest the build and then turn back the other direction was going to take up a majority of the 1,000 feet that you mentioned. And we also, at the time, we were in the moment and we're unaware that we had that we had 1,500 feet that was across in the moment. And at the time, we were only aware of 5 feet. It was only upon the as drilled survey and more information being presented that the entire plat was actually wrong by 20 feet. That we it came to light and this is where we at. We also wanted to play it safe. We were unsure what the board's interpretation would be, and wanted to make sure that we didn't spend capital and commit trespass or anything like that. So at the end of the day, we crossed the line and so we stopped. We're trying to do everything the correct way.
Good. We appreciate that. And I would just hope there would be a simpler way to resolve this rather than having it come clear before the whole board, so that operators can just be forthright. And anyway, I appreciate what you've done here, and it's been very informative. Thank you.
Thank you for the comments. We appreciate that.
Appreciate it.
Mr. Brown.
Thank you, Mr. Chair. I echo Board Member Moon's comments. I have a couple of questions, though, that hopefully you could educate the board. What causes a bit to deviate? I suspect that it's perhaps a change in lithology, perhaps a change in the dip perhaps a change in fracturing. Can you teach us how that occurs? Is it an error with the guy driving the bit? Please comment on that.
There's a lot of factors that may go into that. All of them, some of them that you have mentioned, as well as the fact that you're at 17,700 feet with, downhole tools that have been in the hole drilling for that long, and so mechanical failure is also you can't roll out mechanical failure as well. But hitting a fracture plane and the bit wanting to walk along a fracture plane or something along those lines is definitely, an option or something that could have happened. But at the end of the day, we were attempting to arrest the build and mechanically it wasn't it wasn't doing what we were asking it to do. So.
Thank you, Mr. Atkins. To be honest with you, I'm quite astounded that we can do this, what we do at those depths. It's just astounding to me, and that kind of deviation to me is remarkable. With that, Mr. Chair, I yield back. Thank you.
Thank you. And I see no more comments. I'd like to make a comment on this, and I echo Mr. Moon and Mr. Brown's comments about the appreciation of the fact that you went through the effort to first identify this issue, resolve it, notify the division, and then follow the proper procedures of coming before the board. And makes me wonder if other instances this has occurred but never reported in other situations, which, I guess to me that makes your efforts that much more important, and the fact that you were willing to come forward, maintain a good working relationship with the regulatory agency, and do the right thing. You should be commended on that. A matter has come up that we need to take a quick break, if you don't mind. And Michelle, we're going to go off the record. We should be back perhaps in about 15 minutes. I apologize to take this break, but we'll try and get this issue taken care of as quickly as possible. So we'll go off the record right now. I appreciate your patience. The issue we broke for has been resolved. I'd like to go back on the record as soon as I see if we've got all our board members back. I see Mr. Moon and Mr. Borden so far, and Mr. Brown and Mr. Church. Michelle, can you hear me all right? Great, thank you.
Looks like we're missing
Levon?
Oh, sorry.
There she is. All right. School's back in session. We'll go back on the record, and I believe when we left, the board members had asked their questions of the witnesses, and we would turn the time back over to Mr. McDonald for his summation.
Thank you, Mr. Chairman. Housekeeping, if I could, I'd like to move for admission of exhibits A through F, G is supplemented, H through N, and Z is supplemented.
And that includes exhibits L 1, 2, 3, 4, M 1 to N 1 and 2?
Correct, yes. I listed them as collective as exhibit M, N, and so on.
Okay, so admitted.
Thank you. With that, again, on behalf of the petitioner, we appreciate the board's comments about the way that this matter was handled. Unfortunately, sometimes these things happen with these long lateral horizontal wells. We believe that the statutory and regulatory requirements for granting the exception location approval have been met, and it will maximize the recovery of resources without waste and the protection of the correlative rights in the adjacent drilling unit. And we thank you for the board members for their time and attention. And that's all I have.
Division?
Thank you, Chairman Hanson. I just have a few comments to add. I will jump on the bandwagon with everybody else and really commend CH4 Finley for their efforts in really being a good, prudent, reasonable operator. They, in this situation, exemplified what the division would hope that all operators would do. Following the petitioner supplemental exhibit on Monday, I did take the opportunity to briefly just get on Westlaw and skip trace the 4 individuals whose green cards came back as not received. And I was able to identify more recent addresses for 2 of those 4 individuals. And on a 3rd individual, I identified a typo in the address that I suspect likely led to the inability for that individual to be noticed. So the division does have concerns about the efforts, general efforts the operators take to find and locate individuals in matters that come before the board. And it is also the division's belief that the evidence presented during this hearing sufficiently demonstrates that correlative rights will not be negatively impacted by petitioner's request. And the division believes it's important for the board, as the board always does, to balance the statutory purposes of preventing waste and protecting correlative rights with the rights of individuals entitled to receive notice. So it's the division's recommendation in the immediate cause that the request for agency action be granted. However, the division would like to express the desire to see more robust efforts in the future for locating all individuals entitled to receive notice and opportunity. And that is my comments. Sure.
Thank you, Ms. Susan. Just a question. Did you forward that information to CH4 Finley, the information you were able to find?
I have not done that. I wasn't sure about the appropriateness of me doing their job, but I'm certainly happy to share the information. I just wasn't sure if it was appropriate or not, but I'm happy.
Yeah, I understand, and I'll leave that to you, brilliant legal minds, to make that determination. It was just an innocent question. I hope I didn't put you on the spot. Board members, would you like to deliberate, or do you feel like you've heard enough and understand this issue where we could go ahead with a motion at this time?
I think we did go ahead with a motion.
I'm sorry, Fred? Oh, Fred. Yeah, you have a comment.
Yes.
Yeah, I'd just like to respond to Haley's comment about the searches and the adequacy of that. You know, again, as you do these things, you go off of the county records and you don't know if these addresses are good or not. And the Postal Service takes 2 to 3 weeks sometimes to respond to you as to whether these mailings are good or not. And I believe you heard Ms. Stoley testify they have a service that they utilize to try and find these situations. Now, again, you know, whether, you know, the one that Haley used is a better service or not, that may be questionable. But I do have a problem asserting that the operators are not doing everything within their powers to try and determine these owners. It's very difficult. And you know this, when we get into these spacing orders and you're doing 27,000 mailings, you know, it's very difficult to try and track people down, especially when you don't get notification from the Postal Service that the addresses of record are no longer valid. I just want to make that comment to respond. Thank you.
Thank you, Mr. McDonald. Mr. Brown, you had a comment?
No, I did not, Mr. Chair. Sorry.
Oh, it has a little hand icon on your picture. I apologize.
I haven't lowered that from last time. I apologize. It's gone now.
The joys of electronic meetings. Appreciate all the comments and discussion. Any further discussion? Any response to what Mr. McDonald said, Ms. Souza?
No, thank you.
Okay. Thank you. I understand that the board feels like motion is in order at this time. Would somebody like to make that motion?
I move that we approve the request for agency action from CH4 Finley as written.
I second the motion.
Thank you. The motion's been proposed and seconded. Any discussion on the motion? Seeing and hearing none. Julianne, would you take the roll call vote, please?
Mr. Richard Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. Levon J. Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, how do you vote?
Yes.
Mr. Gordon L. Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
Thank you. The motion is unanimously passed. Mr. McDonald, will you prepare the order?
Certainly. Thank you.
And thank you all again for the fine work that you did in coming forward with this matter. Appreciate it. Hopefully others will follow your example. Yeah. That concludes this particular matter. And I believe that the next matter, in the rulemaking, it might take us some time. So it seems appropriate that we would take our lunch break now. It is about 1:45 p.m. So if there are no objections, we'll break for about. I just remembered we've got to discuss our environmental awards. So do you think we can get that all done by 1 o'clock?
I thought it was to be a working lunch, Mr. Chairman.
Yep. Do you think we can work through it in 1 hour and 15 minutes? Anybody?
How many submittals were there?
Go ahead, John.
5 or 6. More than that.
Mr. Chairman, I think we can get through it in 1 hour, but you may want to give 10 minutes or so for board members to go grab their lunch and then return to the meeting.
Okay, so if we were to come back at 1 o'clock to be back on the record, but the division, board, and public meeting could start, say, at noon. Any objections to starting our discussion on the environmental words at noon? No, seeing none. That's what we're going to get stuck with. So we'll go off the record. We will come back at noon to go through the environmental award applications, and then at 1, as close as we can to 1, we will go back on the record. So, thank you, and we'll go get lunch. we're back at it, at least for the lunch, working lunch on considering the board's Environmental Achievement Awards. I think the simplest thing to do on this is turn this over to Ms. Holly Brown, unless somebody else has a better idea.
No, I think that sounds like a great idea. Thank you, Mr. Chairman. As you mentioned, we're here to discuss the 2021 Environmental Excellence Award nominations. So you should have received the 6 nominations that Miss Julianne Carter had sent out a few weeks ago. And so I think just to proceed, I have Deputy Director Dana Dean and Bart Kettle, who will be kind of discussing the nominations in their respective areas. So the first one on the list is Karis Oil and Gas, and they have submitted a nomination for the Greater Natural Buttes for outstanding final reclamation or site restoration. So with that, Bart or Mr. Kettle, I will turn it over to you.
Thank you. This nomination is for advancements in reseeding efforts. And it's not an item that is required by the division. It's not entirely clear to me if this is activities occurring on federal lands that may be required by some sort of federal regulation. But it is interesting that the submission entertains different methods for increasing the establishment of seeding. And I, for one, would be interested in seeing what the results are. And I think the industry could benefit from what kind of results they got if they are willing to share that information.
Okay, so with that, are there any questions from the board or is there any discussion before we take a vote whether yes or no to invite Karis to come and give a presentation at the April board hearing?
I was just going to ask Rich a question. You know more about reseeding than the rest of us do. Is this something that you think we should hear a presentation on? We can't hear you, Rich.
I'm remiss, and I haven't seen what was sent in. I guess I lost track of that email from a couple weeks ago. So I'm afraid I can't comment with the information that I've just been told. I'm looking for the email right now.
Yep. What date?
Better late than never, maybe.
What was the date on that, Julianne?
It was February 22nd, Monday.
Who was it from?
Julie Carter.
Yes, I'm here. I'm sorry. The date on which item?
You sent out the email with the Excellence Award nominations on February 22nd at 3 p.m.
Could someone just hit forward on that and include me in it?
We're all looking for it.
Yep, I can forward this maybe.
Holly, while they're looking, can I ask you, are we limited on the number of presentations that can be done in April?
No, we are not. So we have a total of 6 nominations, and yes, we can listen to all 6. Each presentation we limit to about 10 minutes, just so that we can allow time for other hearing matters.
In selecting someone who gets the award, is there one award given, or are there different categories?
There can be multiple awards. And there can be several in the same category. It's just mainly the criteria is going above and beyond what is expected by normal regulations. So
thank you.
You're welcome.
I just have read their submittal.
I found this. Who wants it?
I do.
Who's I? Was that Gordon?
Gordon.
Okay. I'm sorry.
Sorry,
Rich Gordon. Anybody else want it? Do you want it?
Well, I've got it.
Okay.
I sent it to Gordon, but it may
Okay.
not go.
Having read it,
Holly, I actually read and and looked at all of them, but I think it would be wise if we just put a picture up again so everybody's memory could be refreshed. Can we just throw one of those PDFs up on your screen? I did read them all.
It's been a while.
I think Holly would have to try and do that.
Who is this?
Yeah, I'm going to.
Holly, I can do a screen share on this one if you'd like.
Okay, yeah, if you could do that, that would be great. Thank you.
So this is Rich. Having read through it now, it seems like it's worthy of a presentation at the very least. It's a fairly large acreage they're talking about here, over 100 acres. It sounds like they've tried several different techniques that I think are above and beyond standard practice. So hopefully they're keeping good records and they're going to approach this as like a scientific study so that there can be some of the results that are of use to maybe the broader reclamation community.
I would agree with Rich. I would like to see more on this one.
So should we do take a vote right now to see how many, or are we all in agreement to have them come in April?
Maybe Holly, is there anybody that doesn't want to see them?
That's the better, yes. Are there any board members that do not want to have Karis Oil and Gas come and give a presentation in April?
Bring them in.
Okay. So with that, then I will notify Karis that they will be coming to give a presentation. And I'm assuming it'll still be a virtual meeting in April. Moving on, then the next item is Dominion Energy, and it's the Questar pipeline system with their methane emissions reduction program. And again, Deputy Director Kettle will be discussing this.
Okay, hopefully I have successfully shared my screen. If I find my cursor again, that will be great. So this submission is for methane emission reductions connected to maintenance of pipeline infrastructure. It doesn't specify in it as I see it, rather that is in designated non-attainment areas in the Uinta Basin, or overall. I read it to be overall within all of the infrastructures. However, it does list towards the end of the write-up 2 fairly significant increases in the amount of gas that is prevented from being vented. So in my mind, I would like to see what is being done on this. It's not clear to me whether this is required by air quality regulation or not, but it's certainly not required by the Division of Oil, Gas, and Mining.
I agree with you. I'd like to see this.
These guys sent us a PowerPoint presentation already, correct? So, I mean, that's basically what you're going to see is what they've already sent you. And I agree, Bart. I think we should let them come in and present this as well.
Okay, thank you, Mr. Brown. And I can put the PowerPoint presentation up if you would like, but I wasn't able to share it on one screen. It's a series of slides.
No, I think we're good. Any objections to having them come and present, board members?
I think this is good. Methane's such a powerful greenhouse gas, and these fugitive emissions are really important to go after. So I like it.
Okay.
Holly, this
Yes.
is Mike Brown. There's one overarching thing that the board looks for every year, and if you would just remind these people when they come in to meet with us, we are looking for above and beyond the call of duty. And so when they come in and present, we're going to be looking for, okay, well, would you have been required to do this? Is it normal? And so those of you that are sponsoring these people from the division, that's what we look for. So again, when they come in to present, make sure you tell them that's what we're looking for.
Okay, yes, and I usually do in my letter, but I will make sure to underline and bold it in the fine print. So yes, I will be happy to do that, Mr. Brown.
I mean, even
Okay.
a summary statement at the beginning or at the end or both of why this is better than the best, or, you know, something that
Sure.
helps us see why they're deserving of this award that we give.
Yes, absolutely. I will make sure to let them know that.
Thank you.
So that is a yes then for Dominion Energy, also coming in April. The last oil and gas item is from MPLX, which is Utah Gathering and Processing, environmental improvement to an active mine site, drilling or recovery site or field. So Mr. Kettle, this one again is yours.
Okay, thank you. This submission is also related to emissions. If we look at scale, there's significantly less emissions noted in this write-up. However, one of the things I noticed is it speaks about these facilities being located within the non-attainment area. And it does appear that it may be outside of regulatory requirements, that the activities being done is certainly out of the Division of Oil, Gas, and Mining's regulatory requirements. I've got the summary write-up displayed. I'm going to go ahead and scroll down to a table that was also provided with the submission. If any of the board members would like me to be on one page or the other, please let me know where you'd like me to scroll. And I guess I probably didn't relay to the board because it appears to be an activity where they're attempting to prevent emissions for regulated activity, but not regulated at these sites. It does, to me, strike me as being an item I would be interested in hearing more about.
So Bart, you're recommending you'd like to hear this?
I am. I'm sorry, I don't think I covered that initially.
So they're saying they're reducing emissions, but aren't they also conserving a product? I mean, is this a marketable product or is it a waste that's going into the air?
In my reading on this, Mr. Brown, it would be leaks of potentially a marketable product.
Yeah, so I mean, it's a payout for them to keep their product from leaking. Again, I guess have them make sure and tell me why that warrants an environmental award. I'm happy to hear it if that's what you're recommending, but.
This one almost seems more like normal course of business, things they should be doing, but I'm not against having them come in and present.
It is something we think they should all be doing, but the industry, traditionally has not been as good with these small fugitive emissions. So it's a good thing. And if it pays for itself, it's even better, I suppose. But I think it's worthy of hearing them.
Just a comment. This is for natural gas. It looks like, and natural gas is in the field, unfortunately, not very valuable. So, and as Rich said, methane is a really high greenhouse gas. So I think we should hear them.
Are there any board members that do not think that they should come and give a presentation in April?
I didn't hear any objections earlier, so I'm assuming that we're all in favor of it.
Well, then I will, so then we will have MPLX come and give a presentation in April as well. And now we are moving on to, we have a few minerals nominations. And so Deputy Director Dana Dean will be presenting those. So the first one is from American Gilsonite, their Bonanza area, and it's for outstanding final reclamation or site restoration. So Deputy Director Dean.
Yeah, I'm trying to bring up their PowerPoint here.
Oh, okay.
Is that
you.
up? Can you see the American Gilsonite PowerPoint?
It's
up.
kind of, yes.
Okay.
Looks like an oil well.
It probably is. This is just a picture out in the, oh no, it's a head frame. Anyway, American Gilsonite purchased some Ziegler properties a few years ago. They didn't get many reserves with that purchase. They got a lot of abandoned portals and head frames and things like this. Last year with the pandemic, they did not, they weren't getting a lot of sales of their product, so they didn't need to mine. And instead of laying everyone off in a county that was struggling already, they kept their workforce on and they paid them to go out and do a whole bunch of reclamation work. They reclaimed 14 total locations and 9 full mine sites. The reclamation work was very good, but none of the actual work itself was above and beyond any regulations. They would have had to do this reclamation at some time in the future, but they could have left this for years. We changed our suspension rules last year, and I heard a lot of concerns from the board about mines being left in place that may never mine again and just sitting there for year after year. So they could have left this for many more years as long as they kept it bonded. They could have laid off their workforce and affected the county, but they decided to spend money and they weren't having an inflow of cash. Again, they were not selling as much as usual, so they did not have an inflow of cash at the time, but they thought it was important to keep their skilled workforce and also to do this reclamation. So again, the work itself wasn't above and beyond, but the fact that they did it now and they kind of did it to benefit the county and the people that work for them is what is being nominated.
Okay, does anyone have any questions regarding American Gilsonite?
Boy, it's very commendable work. I'm glad they did it, but I wonder how we get to the above and beyond. I mean, it's great that they chose to do it now instead of deferring it till the last possible minute, keep kicking and screaming. But
Are there any board members that, so after Mr. Borden's comment, are there any board members that would like to see American Gilsonite come and give a presentation in April?
Dana, what's your recommendation? You just told us what was going on, but you didn't give us a recommendation.
Okay, I would recommend hearing them. I have heard very strong feelings from both April Abate, who is the inspector for that county, and Paul Baker, that they're very impressed with what they did. Although it's hard to point out anything above and beyond, this was impressive to them as members of the mineral staff, and they feel like the board should at least hear the presentation and get more information from American Gilsonite.
Yeah, and in their presentation, they do say they took additional steps above and beyond by capping the shafts to ensure long-term stability, by improving environmental sustainability through separation of materials for recycling, and promoting successful regrowth of vegetation through research, seed selection, etc. So they're saying they are. I don't know if
that would be a good question to ask them if you bring them in person. I think that I didn't really see anything above and beyond, but I could be missing something that they maybe didn't articulate well in the application.
I say we let them come.
I think it's worth seconding Mike Brown's comment that they should strive to show some above and beyond in that presentation.
Okay, duly noted. So are there any opposed to having American Gilsonite come then in April? It sounds like you're all
I think
on
we're
board.
good. I think this one falls a little bit into the political arena too. That,
Okay.
we should probably hear them out based on whether or not they can demonstrate they've gone above and beyond, but also knowing that people are going to be looking at this and saying, okay, do we want to encourage this kind of activity during a pandemic where people are losing their jobs? I realize that's not one of the criteria, but something we may want to be thinking about.
Hey, Chris, is UMA going to have a convention this year? Do we know, or they already canceled it, or?
They have not canceled it. I assume if they have it, they'll do it electronically again.
I mean, one of the gut checks for me is how the membership of the UMA is going to receive this when, we go up and present it to them there in that forum. So I'm not opposed to them coming in, Holly, but it's an interesting one for consideration for sure.
Yeah.
Okay. Well, I will let them know that to plan on a presentation in April. And if there's any, justification for above and beyond, to definitely bring that in their presentation. The next presentation, Dana, or do you have a preferred slide up?
Canyon Fuel did not submit any pictures, so I'm not going to bring anything up for that one.
Okay. Are you ready to discuss Manti LaSalle Forest Service?
I was going to do Skyline next, but.
Oh, if you're ready to do Skyline, we could certainly do that.
Yeah, let's go with that one first. The Canyon Fuel Skyline mine helped out with an abandoned mine reclamation project. In the Clear Creek area, there were some old coal refuse piles that were in the floodplain, and they were causing some contamination and problems with water quality in that area. The Abandoned Mine Land Reclamation Program decided to remove all of that refuse from that area to make it safe. The only way to properly dispose of that refuse is to either bury it in a permitted refuse pile area or pay a lot of money to take it to someplace like ECDC or something like that. So the Skyline Mine actually has a waste rock facility that was approximately 6 miles from this AMR project. Chris Rohr, the project manager, approached Skyline Mine and asked if we could take this material to their permitted refuse site. The mine agreed. By them agreeing, it saved the division money. I'm not sure exactly how much that may have been. There was an estimate in the email, but it did save the division money. And I feel like it was above and beyond because it may seem like a small thing to say, oh, yes, you can put your refuse in our pile, but that reduces the capacity for them to put their own refuse in that pile. So as they're mining underground, and my understanding is that the more that they mine, the more they're getting into areas where they're hitting some dikes and faults, and they're producing more refuse. They may need to acquire more property and do permitting work in the future because they allowed us to take up that space in their refuse pile. So this might seem like a small thing to some people, but it did help the Abandoned Mine Reclamation Program, and it is something that, the Skyline's not benefiting from this, and in fact, in the future, it could cause them to have to spend more money on permitting and expanding their refuse pile if they need more area there. So I would recommend that we hear from them.
I agree.
I agree.
How did the highway get built right there, right next to it, and not be on it? It's just interesting, the location. Just curious about the history here.
Of the old refuse piles?
I'll
the
bet
ones
you
that
that-
we removed?
I bet you the highway's on top of it too, Gordon.
Yeah.
Okay. Yeah, just the pictures, it's like they're digging right between the highway and some old tracks, and it's just interesting that it's a problem now.
Well, I forgot that there are pictures in here, but that's the thing. When our abandoned mine program started, they went after the biggest issues first. This was something that maybe wasn't as bad of an issue, but it is something that we felt like needed to be cured. But, the bigger abandoned mine projects were done over the last 30 years. So this was an important project, but not one of the most important ones when the program started. And they have to balance, what funds do we have this year? We can only do so many projects. Which ones are the most important? So that's why it took so long to do this project. And probably at the time the road was built, the people building the road didn't think that was a problem or a hazard. In fact, I think it was brought to our attention by nearby residents. And we went and took a second look at it. In the beginning, I think the abandoned mine program said we have bigger fish to fry, and they left it. But in the last 5 years, someone came to us and said, "Hey, this really is a problem. Could you please help us here?" And we were able to do so with our grant from the Office of Surface Mining.
Dana, this is Rich. I see from the document that the total removal was 1,675 cubic yards, so not very much, really.
Right.
Big was this, has this consumed 0.1% of their stockpile? Is it just a...
I don't know. They do have a pretty big waste rock site, but again, it does. Even though it's a small amount, they didn't have to help us. We would have had to spend a lot more money removing this to any other site or making our own site. They saved us not only costs at a site, but the trucking costs because it was so close. So again, it might seem like a small amount, but I do feel like they went above and beyond, and they've
Okay, I agree they went above and beyond. It's really...
They've always helped us too. This is not the first time, and I guess they've gotten awards in the past too for helping us, but Canyon Fuel has been very helpful anytime we've approached them with an AMR project with various types of help.
Seems like they've done a lot of labor for us too.
Okay. Are there any other questions? Seeing none. So is there anyone that does not want to have Canyon Fuel come in April? It doesn't sound like it, so I will mark them down as they will be attending in April. And then the last nomination is from the Manti LaSalle U.S. Forest Service for their Dream Mine. And there's for a bunch of reasons, compliance, outreach, and
right.
Anna can discuss that more. So,
okay. So again, this is the Dream Mine. It's in the Manti LaSalle area. It was a productive gold mine in the past. Last year, the person who currently owns the claims there went and breached this old portal. And as you can see, some gunk came to service, and he did not have a permit from the Division of Oil, Gas, and Mining. And again, some contaminated water came out, stained the area. It didn't really go too far, but we didn't want this to continue to be an issue. The division wrote enforcement on this. We wrote a cessation order and a fine, and we asked for this person to either reclaim or get us a mining plan and a bond and to pay the fine. They have been unresponsive to the division. The division likely would have had, since we had no bond on this and the person's unresponsive, we would have had to spend possible state money to take care of this situation, and we wouldn't likely have been able to do it in the time frame that the Forest Service did it. The Forest Service mobilized last fall. They got out there and on their own this was what the operator put in when they were told to close the portal, this door. This is a bat area. So the Forest Service, again, at their own expense and expertise, they went in and they put in a nice bat gate, as you can see, and they closed this a little bit better. I think that I think this is above and beyond. Some would say, well, they're the land managers. Well, shouldn't they be protecting, their own property? Which is true, but in the past, some other land managing agencies have let things fester until the division had to spend the time and money to take care of them. And also a very similar situation, the Golden Dragon mine that the Forest Service closed a few years ago did receive an Environmental Excellence Award from the board for doing this same type of thing. So this got done in a matter of months rather than a year or more that it could have taken the division, and the division did not have to spend any further money on enforcement or the work getting this closed. The Forest Service took that all on themselves. They did coordinate with the division, and so what they ended up here with is a very good closure that we, that looks like something we would do, and we're very appreciative that they acted so quickly and coordinated with us.
Dana, do you know what kind of claims hold this property? Are they loads or plasters, or it's not a fee?
I do not know. I could find out, but I don't right now. No.
I don't know if that's relative to this issue, but I'd like to understand why the guy thought he had a right to even open it.
Well, so I don't know the type of claim he has, but it's not a patented claim. He does not own the surface, but he does own the mineral right. And I don't know why he thought he could just go open it without permits, but we've seen that before. And again, we'll probably continue to try to get our fine from this person, but I doubt we would have ever gotten enough money to actually close this, and the state would have ended up having to pay the tab. And we just appreciate that the Forest Service found funding and mobilized quickly and got this taken care of.
Are there?
I like this one. I guess I don't have enough experience to know if going from a pH 8.3, which is very basic, to a 7.8 is still basic, is a problem, though.
Yeah, I think I don't think
we're not seeing acid drainage here.
No.
Levels I'd be too concerned about.
No, and again, it didn't really go very far either. I think the staining was more of the concern than water quality. There were no fish killed, but it did open a dangerous, attractive nuisance that hikers may have become curious about and tried to enter, and this keeps them from doing so. And again, the division would have pursued this had the Forest Service not stepped up, so they saved us the time and money that we would have spent pursuing this closure.
I'm good to see this one.
Are there any board members that do not want to have them give a presentation in April? Okay, not hearing any, then they will also be invited to come and give a presentation. So in summary, we have all 6 nominations. I will contact the nominees and have them be prepared to give presentations to the board at the April hearing, at the briefing session, and plan to be prepared on why they are deserving and why they have gone above and beyond. So with that, Mr. Chairman, I believe that we have had a successful working lunch and have done what we needed to do, and it's only 12:36. So with that, I am done.
Thank you.
Thank you.
Appreciate that. Appreciate you putting that together, and We'll look forward to seeing those folks next month.
Great.
Since we did finish early and I was wolfing down my food, I assume everybody else did at the same time, but I was too busy eating to watch.
I'm still eating, but then I'm a slow eater, so.
I'm just wondering.
When we get done, so.
I'm wondering if it'd be appropriate to try and start a little earlier than 1 o'clock. Do you see any issue with that? Yeah, well, shoot.
As long as they all reappear, Mr. Chair, but if they don't, they can say you said 1.
Yeah. All right. Our legal counsel's recommending that we go ahead and wait till 1 so that we don't create any issues with people feeling like they have not been heard on the rulemaking matter. So I guess we'll end this part of it and come back and go on the record at 1 o'clock sharp. Thank you. Thank you. We'll go back on the record as soon as I confirm that the members of the board are here and that Michelle can hear me fine. Yep, thumbs up from Michelle. I see Mr. Brown and Ms. Garrison and Rich and Mr. Gordon, Mr. Church, and Susan is here with me. I think we've got the quorum. So we will go back on the record at this time. We have essentially one more docketed item to discuss. Before I move on, yes, one more docketed item, number 4. The docket number 2020-033, cause number RO&G 2020-02 in the matter of formal rulemaking to develop procedures for assessing administrative penalties resulting from Senate Bill 148. And before we open this up for discussion, I wanted to read something. Before we start our discussion on this docketed item, I think we should clarify a few items for the record. In one of the public comments received since the last board hearing on this matter, a member of the public, through counsel, alleged that the division had been apprised several times that the statutory public notice requirements in this rulemaking had not been followed. The board takes such an allegation very seriously and therefore engaged legal counsel for the board to analyze the merits of this allegation. This analysis revealed that first, this comment was the first time a member of the public had raised concerns with the process and the public notice requirements related to this rulemaking. Second, and more importantly, the analysis revealed that this rulemaking process has complied with all public notice requirements under the Utah Administrative Rulemaking Act, the Open and Public Meetings Act, and the board's own administrative rules. Therefore, the board finds this comment is without merit and the rulemaking can proceed accordingly. Now, at this point, I believe I will turn the time over to the division. Who from the division will be leading their discussion?
It's going to be me, Chairman Hanson. This is Charles Lyons. Okay,
thank you, Mr. Lyons. If you would go ahead and begin your presentation. I would like to say that I'd like to keep as close to the matters at hand as possible and stay on track as much as we can in this matter. Don't want to get into wordsmithing by the board or members of the public or the division at this time unless it's absolutely necessary. So if you would go ahead and proceed, Mr. Lyons.
Okay, thanks. I'm going to go ahead and share my PowerPoint presentation, if I can find the correct one for that. And you can see the PowerPoint for you?
Yes.
Okay, great. Thank you. So by way of review, we're here to discuss the administrative penalties rule. This was directed by the legislature to be carried out in SB 148 of the 2020 general session, directing the board to create administrative penalty rules, establishing a standardized violation schedule for violations of division rules and permit requirements, and to establish the appropriate administrative penalty amounts for each violation. It's also wanted to point out SB 6004 of the 2026 special session does not allow the board or division to make, amend, or repeal a rule if formal rulemaking was not initiated on or before July 1st, 2020. So this rulemaking has proceeded as mandated by SB 148. So that's why we're here doing this still. And so I just wanted to kind of briefly go over where we are at today and where we've come from. We're in formal rulemaking. This started on October 30th on this timeline before you that it starts with January 27th because that's the the last time that this was presented before the board at a hearing. We've now had 2 periods of public comment. We've received public comment from Utah Petroleum Association and most recently other interested parties involved with waste disposal facilities. The division has evaluated all the comments from the first round of public comment and presented that to the board at that January 27th hearing. And so today I'm going to provide a summary of the changes being made in response to public comment and what was discussed at stakeholder engagement meetings. And finally, just want to articulate that because we're revising the rule and changing more than 10 words, the Office of Administrative Rules considers this a substantive revision requiring resubmission, which would put us into another round of public comment. So what we're asking the board to do today is to direct the division to submit this version of the rules that was filed on Monday to the Office of Administrative Rules for another round of public comment. The first thing I want to do is to just give a brief overview of the public comments that were received by the division and the stakeholder discussions that were held. The division received 4 comment letters towards the end of this last public comment period. And since that January 27th board hearing, has had 3 stakeholder meetings to discuss the comments and changes to be made. And I'm sure the division appreciates Chairman Hansen, your comments before getting into this presentation about the notice requirements, but also wanted to touch on another component in one of the comment letters that was received that requested a public hearing. We're having this public hearing today, which was previously scheduled, but I wanted to just discuss what the requirements are for when a public hearing is required if it's requested in a public comment. So under the Utah Administrative Rulemaking Act, an agency would be required to hold a public hearing upon request if 10 interested persons or an interested association having not fewer than 10 members requesting the public hearing, and that request would need to be received in writing not more than 15 days after the publication date of the proposed rule. So because the request that was made was received by the division on March 16th, it would have had to have been received 15 days after that initial publication in the Utah Bulletin, which was on February 15th. So also just wanted to clarify that for the board in case there are any questions about that, in addition to that notice requirement discussion that was had also. So regardless, we're here today. The division has had opportunity to consider all public comments and was able to discuss them in stakeholder meetings. So this is going to be a brief summary of the public comments that were received and how they were discussed in this most recent stakeholder meeting, which was held on March 19th. There were 6 distinct comments worth highlighting, and I'm going to discuss the division's position for each of these comments. But first, I want to just run through what those were. The first being that the penalties are inconsistent with current division rules. The second, that the catch-all provisions that are listed in those class 1, class 2, class 3 rule classification sections, that catch-all provision was too broad and that the penalties needed to be limited to violations expressly articulated in the rule. The third was that there was asked that amendments need to be made to the division's definition of solid waste. Fourth, in 8.1C in the administrative penalty rule, it was asked that be amended to include these words in red here on the screen and solid waste. So disposal fluids and solid wastes in an unapproved or improper facility or by improper methods. The fifth, there were concerns with who determines what constitutes imminent harm as applied to disposal facility rules and how those determinations were made. And the sixth being that 6.1J in the administrative penalty rule states that inadequate supervision of disposal facilities is listed as a class 1 violation, and that should actually be made a class 3 violation. So the first comment that the penalties were inconsistent with current rules, the example that was given in the public comment was that bonding violations under 649.3.1 would now carry a monetary penalty, but that was fundamentally inconsistent with requiring all non-exempt disposal facilities to be fully bonded before being permitted. And so the division disagrees with this comment. The division existing regulations and this rulemaking does not create any inconsistency with those. What this rule does is creates that standardized penalty schedule for violations of existing rules and permit requirements, and outlines the procedure for how the division assesses penalties of those existing rules and permit requirements. So for example, disposal facilities are required to have an adequate and acceptable bond before the facility can be permitted. So if a disposal facility is operating without a bond, it would be assessed a penalty and ordered to cease operations until bonding was in place. It would not simply be able to pay a penalty amount and continue to operate with business as usual. Again, SB 148 directed the board and division to create a rule outlining that procedure and standardized penalty schedule for assessing administrative penalties for violations of statutory and regulatory requirements. So that's what this rule does, and it does not create inconsistencies with existing rules. The second comment, that those catch-all provisions in the rule classification sections are too broad and need to be limited. The division agrees with this comment. And so this slide shows the language referenced. I'll just run through real quick. 6.1N is an example where it states any other violation not specifically listed in the rule. And the division agrees that this is too broad. And there is an amended change to those sections, which I will highlight later in this presentation. But I just wanted to say that the division agreed with this comment and the change is going to be made to address that. Third comment, that amendments need to be made to the division's definition of solid waste. It was agreed that this and similar issues would be discussed in future stakeholder meetings specific to waste disposal facilities, because this goes beyond the scope of this rulemaking. The fourth comment, that and solid wastes should be added to 8.1C to say disposal of fluids and solid wastes in unapproved or improper facilities or by improper methods. So the division disagrees with this comment for two reasons. First being because, as I just stated, solid waste would remain an undefined term that would be taken up in future rulemakings. And secondly, this 8.1C is based off of violations of R 649.315. And that rule only deals with fluid and liquid wastes. That rule does have a reference to the term miscellaneous wastes. However, because all the other types of waste expressly articulated in that rule are fluid or liquid, the division believes that it would be unwise to rely on that term miscellaneous waste as a substitute for solid waste, especially considering that it would be addressed in a future rulemaking and stakeholder discussions, specifically at disposal facility rules. Fifth is another comment that was agreed to be beyond the scope, was that there are issues with who determines and what constitutes imminent harm for violations at disposal facilities. So again, just beyond the scope of this rulemaking, and will be discussed further in future stakeholder engagement in a more appropriate forum. The sixth comment for 6.1J, it states that inadequate supervision of disposal facilities in the rules is listed as a Class 1 violation. And the request is that that should be made a Class 3 violation. And the division disagrees with this comment for two reasons. First, that change would conflict with specific language, which differentiates Class 1 violations from Class 2 and Class 3 violations, and that the rule includes aggravating factors that would increase a Class 1 violation to a Class 2 or Class 3 violation. So the division believes that it's appropriately listed as a Class 1 because there are varying degrees of inadequate supervision, and would prefer to have the discretion in each instance to make that determination. It's important to highlight what the specific language used in those rule classifications, which differentiate one another. Class 1 violations present a low direct risk or threat of harm to public health, safety, and welfare. Class 2 violations would present the possibility of distinct, identifiable, actual, or threatened adverse impacts. And Class 3 violations would prevent a significant probability of actual or threatened adverse impact. So not all instances of inadequate supervision would be a significant probability of actual or threatened adverse impact. And this is just more appropriate to leave as a Class 1 violation. So those are the 6 comments that I wanted to highlight. And now I wanted to move on to what the changes that were made to the rulemaking this time around. So when this rulemaking was last presented to the board at that January 27th board hearing, there were 2 remaining concerns. The first is listed here regarding the use of the term environment in the rule. The second dealt with the appeals process, and in particular, how the previous rule referenced cessation orders. And so the third item is one that I referenced earlier in this newer round of public comments that were received, dealing with those catch-all provisions being too broad. So I'm going to go ahead and discuss the division's recommended changes to the rule that is before you today, and are the result of multiple stakeholder discussions that have been held. So these are examples of how the rule used the term environment in the previous version. And the term environment as used in those was changed to a defined term of resource detriment. So environment, the issue with that was that it was undefined and overly broad, which might include things that would go beyond the jurisdiction of the division and the board. For example, there were concerns that issues related to air quality and/or contributions to climate change might become factored into penalty amounts. So what the change is the defined term of resource detriment. I'm not going to go through and read this whole thing, but this is the defined term. And what this does is limits the scope of the rule to keep the rule within the division and board's jurisdiction, and address the concerns of the previous public comments. And this has been vetted in stakeholder meetings, and everybody agreed that this satisfied what the issue was with using that term environment previously. And so what that looks like now in the rule, again, this is just the same examples that were up before, essentially just substituting that term environment with this new defined term of resource detriment. The second change is the addition of this emergency order section, clarifying and addressing the concerns surrounding cessation orders. So the concerns previously dealt with equating cessation orders with division enforcement orders and the appeals process therefrom, but also the potential for cessation orders creating a situation where waste might occur. And so through stakeholder engagement and changing the language to include cessation orders under this specific emergency orders section in this administrative penalties rule, those concerns were resolved. And finally, the third change that I wanted to highlight is just that catch-all provisions reference. Previously, what that stated, 6.1N, any other violation not specifically listed in the rule. That language of just any other violation not specifically listed is too broad. The division agreed. And so the change that was made is any other violation listed in the division's rules R649 or Title 40, Chapter 6, the Oil and Gas Conservation Act. And that was just substituted into those specific class 1, 2, and 3 catch-all provisions. And that keeps this, any other violation that may be issued to violate existing rules and regulations and statutory requirements. So again, I just wanted to put this timeline before you again, and just emphasize that because we're changing more than 10 words, the Office of Administrative Rules considers this a substantive revision, requiring resubmission of the rules and going into another round of public comment. So what the division is requesting today of the board is that the board directs the division to submit these rules to OAR and to be published for another round of public comment. I also just wanted to mention, what happens next. So when the May 26th board hearing would take place, if the board adopts the rules after that public comment period, if everything is satisfied, we've had multiple public comments now, so hopefully any issues have been resolved at this point. The board could decide to put the rules into effect immediately or choose a day, but regardless, those rules would go into effect 7 days later by default. And that concludes my presentation on this. I can keep sharing my screen if there are any specific questions, and it might be helpful for me to go back to highlight anything, but that's all I have for you today. Thanks.
Board members, do you have questions for Mr. Lyons on his presentation or matters included in his presentation? Seeing none, I think it would probably be appropriate then to let those members of the public who are currently participating to make any comments on this particular set of issues. Any comments that anybody would like to make? Oh, sorry, I didn't notice, Ricky, that you had asked to make a statement or a comment.
Yes, thank you. Ricky Renko Browning on behalf of the Utah Petroleum Association. I just wanted to thank the division staff for a significant amount of work with stakeholders to get to the draft that we currently have. It has indeed been quite a process, and we really appreciate the cooperation and the time of some of the board members in working through this as well. UPA, based on a significant majority of our membership, though in full disclosure not unanimous position, supports the current draft being proposed for approval today. Happy to answer any questions if there are any, but just wanted to confirm that the majority of our members do support the current draft, and we appreciate the work done so far. Thank you.
Thank you. I second what you just said about participation of stakeholders and working through this on sometimes difficult issues. Mr. Brown, I saw you raise your hand at one point. Did you want to make a comment?
No, I'm good, Mr. Chair. Thank you.
Well, okay. Thank you. I would assume at this point that a motion would be in order for the board to ask to have the rule resubmitted to OAR for another round of public comment and hearing, or I guess, yes, hearing. Is there a motion before the board?
I'll make that motion, Mr. Chair.
Okay.
Mike Brown.
Rich Borden seconds.
Thank you. Any discussion on the motion? Hearing and seeing none. Ms. Carter, would you please call the roll call vote?
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. Levon J. Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon L. Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
Thank you. The vote was unanimous, and I would, at this point, Mr. Lyons, I assume that you'll make arrangements for the rule in its current status or current edition be resubmitted to the Office of Administrative Rules for another round of publication and comment.
Yes, sir. The division will make that happen.
Well, thank you. We have, hold on just a moment. I wanted to address one more issue today concerning Utico and a matter that I think we're getting close to closure on, or at least we're progressing. And I believe Haley, Ms. Souza, if you'd like to update the board on where we stand with Utico.
Sure. So the division submitted a memorandum detailing its investigation and negotiation into this matter on Monday, I believe it was. And in that memorandum, the division recommends that this matter be set for a hearing.
I'm sorry, Ms. Souza, I neglected to put this into writing, so I'm struggling a little bit here. As I understand it, the division is requesting of the board to have a motion to move this Utico matter forward.
That is the division's recommendation, yes.
Board members, do you need any additional information about this, or is there a motion that someone can make to move this Utico matter forward?
Mr. Chairman, what's the alternative?
I can jump in and help you out with that one, Mr. Chairman Hansen. So the statute on this is a really unique statute to Utah specifically, where it allows royalty interest owners to request that the board set well, it's technically a request for agency action, and it is to request the board to set a hearing to determine why proceeds haven't been paid. And the statute then authorizes, or actually mandates, that the division be tasked with conducting an investigation and negotiation into the matter within investigation and negotiation usually looks like as we reach out to the various parties.
I'm sorry. You cut out for me.
Okay,
So and the statute then authorizes or actually mandates that this division be tasked with conducting an investigation and negotiation. There you go.
And the way that investigation and negotiation looks is that we reach out to the parties, we get their side of the story. Do they agree that payments are made? And then in the order that the board issues to direct the division to conduct that investigation and negotiation, it requests a memorandum for the division to make a recommendation. So the statute says that there's really two options. The board can set the matter for a hearing. So I'm in 40-6-9. So it can, well, I guess there's a few different outcomes. So first off is the investigation and negotiation can resolve the matter. Alternatively, the board can set for a hearing. And a third option is if the board does not set it for a hearing, this is in 40-6-9-6B. If the board does not set a hearing, then information gathered during the investigation and negotiation will be given to the petitioner, who may then seek a remedy in a court of competent jurisdiction. So there may be situations where through the investigation and negotiation, the division is not able to make a determination regarding whether proceeds are owed, and that might be a situation more appropriate for a court of competent jurisdiction. In this specific instance, we determined that royalties should be owed all the parties, and they even came to an agreement on the amount of back payment owed to them. But this same statute also authorizes penalties if the proceeds are unreasonably withheld, and it also allows for accrual of interest if the party responsible for paying royalties fail to deposit those monies into an interest-bearing escrow account. So, Mr. Brown, that was a very long-winded way of telling you that there are several options for the board, one of which is to set for a hearing, and another is to say, this is kind of outside of our jurisdiction, we better pass it on to a court of competent jurisdiction.
Thank you, Ms. Sosa. Mr. Chairman, given her explanation, I would move to set this matter for hearing before the board.
Is there a second?
Second.
I can second that. This is Gordon.
Thank you. Any discussion on the motion to set this matter in the hearing before the board? Hearing and seeing none. Ms. Carter, would you call the roll call vote?
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. LaVon J. Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon L. Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
Thank you, Ms. Carter, and motion carried unanimously. And I assume, Ms. Souza, that you'll oversee the preparation of putting this matter before the board?
Yes, sir.
Okay. At this time, before we adjourn this meeting, understand that it may be necessary to go into a closed meeting to discuss strategy pertaining to pending or reasonably imminent litigation. We have a couple of matters that we need to discuss. Is anyone willing to make a motion for us to go into a closed meeting?
So moved, Mr. Chair.
Second?
A second.
Second.
Thank you. Motion's been seconded. Mr. Could you please call the roll call vote?
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. Levon J. Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, Chairman, how do you vote?
Yes.
Mr. Gordon L. Moon, how do you vote?
Yes.
Mr. Chairman, I have 7 affirmative votes.
Thank you, Ms. Carter. With that, we will be moving into a closed meeting using our virtual boardroom. I believe Ms. Carter has forwarded the appropriate link to the parties. And at the conclusion of the closed meeting, the board will reconvene to adjourn this hearing. So we'll go off the current record and then go on to our closed door virtual boardroom meeting. All right, we'll go back on the record. Thank you for your patience. Michelle, can you hear me all right? Yep, I see you smiling. Great. The only board member I don't see is Levon. I wonder if she's been able to make it back. Huh. Well,
While we're waiting for Levon, Mike, what's your mission? What are you and your wife doing?
Are we on the record?
no, let's go back off the record, Michelle.
We're serving what's called the Pathways program. We're helping a bunch of people in Africa get college educations.
Oh, that's wonderful. My cousin runs Zambia Scholarship, and I know the church has helped her. It's a nonprofit organization, and she helps build schools and educate kids in Zambia.
Yeah, that's wonderful. We're actually starting our second year. Our first year students will be graduating our part of the program here in April and matriculating to BYU, Idaho. So it's those people are amazing people over there. So
that's wonderful. I guess the only other thing to say is thanks for your service. That's a tough thing to do.
Oh, it's been a joy. It's with mixed emotions leaving this board. It's been a wonderful experience to be on the board with all of you. So.
You're not off yet, Mike.
I know, Mr. Chair. I'll continue as long as needed.
Ooh, all right.
Aren't you Vice Chair, Mike? just checking.
Mr. Vice Chair, I may not be around next month. Well,
no, don't read anything. Don't read anything sinister into that.
We'll go back on the record, Michelle, and having completed the matters before the board, I would entertain a motion to adjourn.
So moved.
A second? Is it required? If not, we're adjourned. Mike Brown and Levon, we will use the deliberation link to have our discussion here in a few moments.
Okay.
We'll see you there. Thank you.
Great, thank you.
Hopefully see you all in person next month.
Yeah, really.
Let's keep our fingers crossed.